Whew. Hey y'all, it's me. It's your girl. And you already know. Like, share, and subscribe. What's up, real deal? I'm at home, y'all. Y'all know I rushed to this verdict. So I'm sitting here and I'm waiting to see what these folks gonna say. So y'all come on in. We gonna talk about it. I heard the closing argument. I already knew what it's gonna be. Now I need to hear what they're gonna how they gonna vote. So that's what we waiting on now, okay? Come on, real deal. Y'all know we don't work hard on this case. Now come on. Come on. Something. Something we've been waiting on. Yeah, I want to say also shout out to all my mods and my subscribers, the viewers for watching and sticking us with this case. What I really want to see it to be first degree. I don't need it. Don't need to be second degree. So let's just pray that the jury get him the death penalty, but his own brother and his defense and the comments said it was easy. We just can't wait. I just can't wait. So right now we don't know what it's gonna be, what it's gonna turn out. But I heard the last part of the opening. Y'all got to think about the jury now. Now we got to deal with the jury. The jury got to make the decision now for us. Right now we got a blank page. They got it blank, but so I don't want to blame nobody. So we'll sit and wait. Ooh, y'all, this cake don't blow me out. Oh my God. Shoot. I'm proud of myself. I didn't go to sleep this morning. I fought it. I fought so hard trying to keep my eye, but I did go to sleep when I got off him. So God is good. He gave me a break. So we gonna sit here and we gonna wait. Yeah, that running. Whew. Right here. I appreciate y'all working with me in this case. Oh, I'm so tired. And I'm gonna drop my link when everybody get in here because I know y'all got a lot to say, about the case, and that's good. Ooh, y'all don't know what they doing. They got a blank page right here. So what I'm gonna do is now if the jury takes so long, what's gonna happen is we still waiting on the jury, and if what's gonna happen here? Hold on, y'all. I'm looking at both of the pages, and they both are blank. So if they come back, and I hope you got to see it ain't the judge, it's the jury. They the one got to vote. So I hope they think about this little girl. Let me see what I can do here. Yeah, the closing the argument was interesting. It was like everything they had talked about. Y'all, I was riding down the road with a chicken bone in my mouth. Still sleepy though. I'm sleeping now. I'm waiting on them to go ahead on and do this, and I'm gonna take me a nap. I haven't taken on nap. I did a couple of TikTok, but I ain't taking on nap. So I'm gonna drop the link. Anybody want to come up and they want to talk about it? Y'all come on in now. We don't. This the end of the roller coaster. On there. So right now we just sitting here waiting. They got a blank screen right here, but we want justice for Iyana. Man, I can't believe that girl ain't him. This should be. I know ain't no young folks looking at her age. 'Cause they ain't supposed to be in school. They should be getting out. So this is a lesson. This is real something. Oh. Woo, Chad, I hope. Woo, Chad, honey. We got some work to do. Let me see how they came on again, y'all. Hold on. There he came good.
Come in and go, oh, ISS, or I'm sorry, SS should have disclosed this quicker. Then we hear, I think they took a shot at Dr. Atchu. They said, well, you know, she's looking down at the floor. She looked concerned. I think there was testimony she wasn't talking. If she wouldn't make eye contact, Dr. Atchu's the one that confirmed the pregnancy. Listen to this. You know what Dr. Atchu said? 22 weeks, 5 days pregnant. That's huge. Why? 22 weeks and 5 days backwards is December 13th, which is the date of the appointment. It was July 7, 2018. You know what July 7, 2018? There was a family get-together. They came back from, remember, way last week. The two little girls went to spend time with Grandma Nancy Ware, but Columbus, Georgia, come back. SS goes home. IS on that night for 2 nights. Went to spend the night with them. That's why the family blew up in early December.
Okay, let me see how they
out.
Got anything.
Then they up here criticizing. Miss Michelle says, well, planning it for months. He knew what he was going to do.
Still a blank screen, y'all. Yeah, they ain't showing them. Let me see. Let me see what else I can look at. Yeah, Miss Michelle. Michelle did.
Turned on. You don't know when it's being turned off. You don't know when it's being restarted again. Mr. Quiles, you heard this from George Jackson, was left alone with Morris McClendon. Morris McClendon, who is an expert at doing these things. He knows how to do what he needs done. He knows how to get information in the way that he needs to, by whatever means necessary. George Jackson wasn't in there when Mr. Quiles and Morris McClendon were having conversation. But what do you hear at the beginning of that wire? There's razors on the floor. Talk about a razor again.
It still haven't came on yet, y'all. I'm watching. I'm waiting on it right now.
Get them to say what you need them to say.
I'm just replaying it today. Come back.
Think about what you heard. Every answer is prompted.
It's something I want to share with y'all.
They're feeding information. They're telling him, signaling to him what needs to be said. What did Mr. Quiles' brother tell you? He makes up stories. He's known for it.
Well, he ain't gonna make up no story like that. Let me show you. I want y'all to see something. I know he ain't that crazy. Well, I ain't gonna say crazy. Let me see something. Hold on, y'all. It's still not on yet, y'all. I'm looking. I'm watching. Wait a minute, did he take the stand? Let me see what it is.
Jury being in court.
Still trying to be cute. I wouldn't want him to look at me.
It says IS was 12 years of age or older, younger than 18. There has been zero dispute that during the 2017 December to December 2018, she was of the age of 15 and 16 years old.
What that mean?
Charged 3 crimes. So we're first going to talk about date and venue. I know throughout the trial, you all heard, is that in Duval County, Florida? That is part of the state's requirement to prove that a case occurred here within this jurisdiction. So that is why you all kept hearing, is that in Duval County? That is why. We have 2 different venues. We are stating for counts 1 and 2 that the venue of the murder of Iyana and her unborn child was at Ace Pick-A-Part off of North Main Street. And I have put an image on the screen, which is state 67. Then I'm going to show you some photographs a little bit later on. We believe, and we're going to argue, that the venue then for count 3 involving the sexual battery occurred at the defendant's residence. And I'll talk about that testimony. And that would have been during the time frame because it's different. So we have December 19th through 20th, 2018 for counts 1 and 2. In count 3, we have a larger range based upon the nature of the case, that charge, specifically the sexual battery. That it occurred on or between, on one or more occasion during December 1st, 2017, and then up through December 20th, 2018. So that is why you all will see the different dates during your jury instructions. So, roadmap. I'm just going to briefly touch upon justifiable, excusable homicide. And obviously, we don't have attempted homicide in this case, so I apologize.
I'm not
for
playing
that.
the whole thing,
I'm
y'all.
just
They
gonna
just
brush
ain't
through it
came with
because
dirty.
it's a
It's still
standard
playing.
requirement in your jury instructions.
All right, members of the jury, welcome back. You guys may have a seat.
Detective King found nothing at the landfill that could be sufficiently connected to IS via DNA or anything along those lines.
Yes, they did.
The evidence technician, Detective or Officer Lillard, they never located a body. They located some items, again, never connected to IS via DNA or anything along those lines. They talk about some underwear. Those underwear that have lips on them that Kimberly Mobley testified, those are IS's. You heard that testimony. Those underwear are a large. IS was a small. She was tiny, she was thin.
But they might run.
Never even heard of someone upsizing underwear before. It's absolutely ludicrous. She wasn't pregnant at the time in February of 2018 when these underwear were purchased. You don't upsize underwear. That's not what happened. Those are not her underwear. And the testing done on it.
Well, their
shows that there
mama
was
bought
no
some and
evidence,
auntie
no
bought
DNA
some.
on that to connect that to IS. Similarly to those two bras that mom says, oh yeah, those look like hers. There's no DNA to connect those to her either. None of those items found in the landfill on a daily basis. But you know who wasn't going to that Bible study? Mr. Quiles. You know what Damian Hatch told you all? They were going to that Bible study every day together.
Hi,
What did Ulysses Dixon tell you today?
Joanne.
That's a lie. They're lying.
So they real
Damian
weak.
Hatch lying.
Real weak.
Mr. Quiles and Damian Hatch, Dino, as he's called, never attended Bible study together. Mr. Quiles didn't even go to that Bible study until the end of 2022, maybe the beginning of 2023. And how did Ulysses Dixon know that? That he'd been trying to get him to
Yeah,
come.
he going down.
Really good guy, doing
Let me
trustee
skip it.
work, helping out people, but he wouldn't go to church.
That ain't gonna work.
He goes,
We better pray that the
it's
jury
just not enough
come
to
out
call
with
one way or the other. And he spent all this time on it. And he says, listen, it was a sperm cell fraction.
Joanne.
That's what he said.
Girl, I'm
But
so
setting
glad
all
you
that
told me
aside,
what.
what the
I'm so
defense
glad
just
you
did
told
with
me to
that
tell
DNA
it.
is they held it
Damn.
up and go, well,
Woo.
it's not really a Z in the alphabet. If you pick it
I
up,
feel
pull it
good.
out, turn it on its side, it's now an N.
But I need the
That's
kind
not
of
what your
jail
job
that's gonna
is.
hold
Your
it.
job is to take all of this evidence,
Hold
put
it down. It's not
together,
holding it down good.
render a true and just verdict. Ladies and gentlemen, that
I do
evidence right
too.
there is the most inculpatory piece of evidence that exists on the face of the earth. And it existed in a place, the last place a 33-year-old man's DNA should be, is in a 15-year-old girl's underwear. And then they bring up, well, these Snapchat. Counsel says, well, it's only half the the way the records came in. We got half the conversation. Listen, you can read it 100 times, and there's no other conclusion. We were asked, and we made it clear, please use your common sense. You can't read those Snapchat messages and draw any other conclusion rather than it was between this defendant right there. No other way to read it.
And you know what tripped me out?
Names are He uses the sister's nickname. He uses your aunt. He uses one time about the whole kiss goodnight. Oh, well, a kiss you goodnight. I'm in your house. It's clear. If that's not M-A-N, and he wrote that John Wayne is this kind of a man. Quote, he had a spirit that makes firemen rush into a burning building because it's the right thing to do. End quote. Joseph Quiles did the right thing. It was the right thing to do. Joseph Quiles broke one of the strongest bonds that exists on earth. And that's a brotherhood bond. He came into a court of law and he raised his right hand and he said, this is what he told me. I couldn't stomach it, so I shot her. I had to get rid of that baby.
I don't know how he thought he was
Counsel stood right there and tried to get him to say, well, you don't believe that. You don't believe that. You bet he doesn't want to believe that. That he sure as heck picked up that telephone on January 8th, 2019, called the police. On January 8th, 2019, remember this, and calls the police. On January 10th, 2 days later, you heard the words right out of his mouth on the wire, matching what Joseph Quiles testified to. Taking the witness stand and doing the right thing. And I asked him why. I said, Mr. Quiles, I said, you tell this jury why you're doing it. He said, it's the right thing to do. We don't tolerate use of family.
The brother.
I wanted the police to have this information so they can go look for her and maybe bring this family peace.
That's right.
Joseph Quiles' testimony alone convicts him. With all these circumstances surrounding and all the evidence that surrounds that confession, that alone convicts him. Lastly, the defense just argued to you that we don't have any evidence, right? They still go, there's all these holes in it. Look at your video board and look at the evidence.
Yeah, I got all the evidence
heard in this trial. I'm not going to read every one of those to you. There is a mound of evidence here. There is evidence overflowing here. There is evidence that will bring us to phase 2 of this trial. There is evidence that the defendant is guilty of first-degree murder of IS, Iyana Sawyer. There is evidence that he is guilty of killing her unborn child. Proof beyond a reasonable doubt. There is evidence we have proven beyond a reasonable doubt that sexual battery occurred on IS by the defendant. That presumption of innocence that you have done nothing but adhere to and pay attention so attentively, you can now just strip that off of them. This case is now where it belongs, and that's with the people. We talked about those 3 branches of government when we started this, the judiciary, the executive, and the legislative.
That's right.
The people that make decisions. It's the people.
It shouldn't take them. Wait a minute, y'all. They back on.
That brings justice.
There it go. They back on, y'all. Now he on hold on, guys. Let me see. Let me see what they're gonna start, computer. Let me see what they doing on their channel. I'm gonna go to this channel too, y'all. Hold on.
Feel free to take notes if you want. Feel free not to take notes, but you will get a hard copy. Jonathan Quiles, the defendant in this case, has been accused of crimes of 2 counts of murder in the first degree and 1 count of sexual battery. Jonathan Quiles is accused of first-degree murder in counts 1 and 2. Degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. You find yes, that's the count 1 and or the unborn shot of Iyana. 2 was killed by within consider the circumstances surrounding the killing, deciding to murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Killing of a human being is justifiable homicide, and lawful is necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in a dwelling house in which the defendant was at the time of the killing. Killing of a human being is excusable and therefore lawful under any of the following circumstances. 1, when the killing is committed by accident and misfortune and doing any lawful act by lawful means, usually ordinary caution, or 2, when the killing occurs by accident or fortune in the heat of passion on any sudden sufficient provocation. A sudden combat, a dangerous weapon is not used. The killing is not done in a cruel or unusual manner.
Hold on, y'all. I'm about to take you out somewhere. Hold on.
A dangerous weapon is any object that will likely cause death or great bodily harm in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Jonathan Quiles will be found guilty of first-degree murder or any lesser included crime. Resulting from a sudden combat, a dangerous weapon is not used, and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Jonathan Quiles will be found guilty of first-degree murder or any lesser included crime. As to count 1, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, IS is dead. 2, the death was caused by the criminal act of Jonathan Quiles. 3, there was a premeditated killing of IS. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. A premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. There will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Jonathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm and in doing so caused great bodily harm to or the death of IS, you should find the defendant guilty of first-degree murder with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and does not include mere bruises. If you find that Jonathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of first-degree murder with discharge of a firearm. If you find that Jonathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access, with the intent to use the firearm during the commission of the crime. As to count 2, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, the unborn child of IS is dead. 2, the death was caused by the criminal act of Jonathan Quiles. 3, there was a premeditated killing of the unborn child of IS. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation was previously defined for you. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Jonathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of the unborn child of IS, you should find the defendant guilty of first-degree murder, discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined for you. If you find that Jonathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find him guilty of first-degree murder with discharge of a firearm. If you find that Jonathan Quiles guilty of first-degree murder, if you find that Jonathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder with actual possession of a firearm. Firearm has previously been defined for you. To actually possess a firearm has previously been defined for you. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are as follows: second-degree murder, manslaughter. The instructions for second-degree murder and manslaughter as lesser-included crimes for first-degree murder are combined into one instruction for simplicity purposes. The only difference is the name of the victim in the elements of the crimes. As to count 2, to prove the lesser-included crime of second. As to counts 1 and 2, to prove the lesser-included crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. As to count 1, IS is dead. As to count 2, the unborn child of IS is dead. Element 2, the death was caused by the criminal act of Jonathan Quiles. Element 3, as to count 1, there was an unlawful killing of IS by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. As to count 2, there was an unlawful killing of the unborn child of IS by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another in demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had the intent to cause death. If you find that Jonathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, and in doing so caused great bodily harm to or the death of IS as to count 1, and or the unborn child of IS as to count 2, you should find the defendant guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined for you. If you find that Jonathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Jonathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. Firearm has previously been defined for you. To actually possess a firearm has previously been defined for you. As to counts 1 and 2, to prove the lesser included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, as to count 1, IS is dead. As to count 2, the unborn child of IS is dead. Element 2, as to count 1, Jonathan Quiles intentionally committed an act or acts that caused the death of IS. As to count 2, Jonathan Quiles intentionally committed an act or acts that caused the death of the unborn child of IS. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as been previously defined to you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Jonathan Quiles committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. Firearm has previously been defined for you. If you find that Jonathan Quiles committed manslaughter, or you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. As to count 3, to prove the crime of engaging in an act that constitutes sexual battery upon or with a child 12 years of age or older, but younger than 18 years of age by a person in a familial or custodial authority, the state must prove the following three elements beyond a reasonable doubt. 1. Jonathan Quiles engaged in any act that constitutes sexual battery. 2. At the time, IS was 12 years of age or older, but younger than 18 years of age. 3. At the time, Jonathan Quiles was in a position of familial or custodial authority to IS. Sexual battery means the sexual organ of Jonathan Quiles penetrated or had union with the female genitals of IS. Ignorance of IS's age, IS's misrepresentation of her age, or the defendant's bona fide belief of IS's age is not a defense to the crime charged. Bona fide means genuine. It is not a defense that IS was willing or consented to engage in an act that constitutes sexual battery. IS's lack of chastity is not a defense to the crime charged. An object includes a finger. Union means contact. Female genitals includes the labia minora, labia majora, clitoris, vulva, hymen, and vagina. As to counts 1 and 2, the state must prove the crimes were committed on or between December 19 and December 20, 2018. As to count 3, the state must prove that the crime was committed on or between December 1, 2017 and December 20, 2018. It must be proved only to a reasonable certainty that the alleged crimes were committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. During the course of this trial, you heard testimony from SS and ID. The testimony from SS regarding other crimes, wrongs, or acts allegedly committed by the defendant shall be considered by you only as that evidence relates to motive, opportunity, intent, plan, absence of mistake or accident, or corroboration of IS as it relates to count 3. The testimony shall be considered as to motive as to counts 1 and 2. Testimony from ID regarding other crimes, wrongs, or acts allegedly committed by the defendant shall be considered by you only as that evidence relates to motive, opportunity, intent, plan, or absence of mistake or accident. The testimony shall be considered as to motive as to counts 1 and 2. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the indictment. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in this case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or a false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, the testimony of such witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand or to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not, in accord with the law. Whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. So there's 3 verdict forms, one for count 1, one for count 2, one for count 3. I'm holding them in my hand. I'm going to go over the one for count 1 for you so you understand how it works. It's difficult for you to see, but once you see it in person, in front of you, it'll make more sense. The top line up here reads, "We, the jury, find the defendant guilty of first-degree murder as charged in the indictment." If that's your verdict, you check that box. Then you make a further finding regarding the firearm that was discussed in the instructions. On the second page is the lesser included charges of second-degree murder or manslaughter and the further findings. Then the last one you have is you find him not guilty. You only check one of the boxes on the far left. First-degree murder, second-degree murder, manslaughter, or not guilty, based off the law that I've read to you. If your verdict requires a further finding, then you go to the indented part of that request, and then the foreperson would sign and date it. Count 2 acts very similar, except it's a different victim, the unborn child of IS. For count 3, it's very simple. He's guilty of the crime charged or not guilty, and you sign and date it. There's no further finding on that one. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. The foreperson will have the forms, fold them in half, give them to Mr. Gray or the bailiff, and then he'll give them to me. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, electronic communication, blogging, Twitter, email, text, etc. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, other electronic devices here in the courtroom. The rules do not allow you to bring your phones or these devices into the jury room. Mr. Gray and the bailiffs will collect them from you and they'll hold custody of them until the end. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote on the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you notice in the jury room, there's a monitor on the wall. It's not a TV screen. It's actually, well, it has no access to anything, internet, etc. It's just a big, essentially big computer monitor. The staff will set it up for you, turn it on for you. If you have any issues with that, let me know. It should have been checked out already. and they'll set you up to where you can put CDs in there, listen, view anything that you guys wish to do throughout the trial. That way you can all see it at one time versus a small computer screen. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So in a couple minutes, the bailiffs will take you back to the jury room. I talked about scheduling. So you guys will begin your deliberations here in a moment. We will wait to hear from you on anything. I need to know by 6 if you guys want dinner. We will order you pizza if that's what you want. If at a certain time you guys want to break for the day and come back tomorrow, you just let us know when, and we will abide by your wishes as a collective group. Juror numbers 73, 75, 86, and 89. To break it to you, 4 were our alternate jurors this week, which means that I cannot let you back in the jury room with the other 12. However, can't officially dismiss you yet. What I'm going to do is go ahead and have the other. Do you guys have any personal belongings in the room? You guys do? Okay. What I'm going to do is, if you guys don't mind, go and get those personal belongings and you'll come back out. And then I'll read you guys some additional instructions.
Some more instructions. Jeez. Wonder what she did. That jury right there did. I wonder what she do. Justice for Iyana. Justify Iyana. You and Henry might well cut y'all ponytail out. That ain't fun. I don't know what they're gonna say. This trial right here. Y'all did a good job of sticking up in here and woo, cause this was tough, huh, honey? Trying to hold my eyes open.
Okay, so to the 4 alternate jurors, I have some additional instructions I need to read to you guys. This is specific to you guys, although it kind of applies to everybody. As you guys have already told you, I can't let the 4 of you into the jury room with the other 12 at this point. The law does not allow me to do so. However, I do not know if there's going to be another phase to this trial, as we discussed during jury selection. What I'm going to do at this time is excuse you from the courtroom and remind you that you are still remain under the order this court not to have any discussions with anyone concerning this case, not to read or listen to any reports about this case. As if the second phase is necessary, I am going to be asking you to return to participate in that second phase of the trial. The reason why we have alternates is because, especially in the cases that last the length that we're here for, emergencies arise, acute issues arise. If that's the case, the alternates have to step in. Fortunately, everyone's remained happy and everyone's remained healthy and here, so we haven't had the need for an alternate to step in. However, that need may arise next week if we go to a second phase. I don't know that right now, which is why ordinarily I would dismiss the alternates and say you're free to do whatever you want. I can't do that yet. You still have to remain under order of the court not to discuss the case like you have the past 2 weeks. However, I just can't deliberate with the other 12 right now. So I don't know if we go to a second phase, I don't know when that's going to occur. We have your phone numbers and we will call you and let you know next. I'll call it. Someone will call you either way. I'll let you guys know either way, because if you're not needed and you're dismissed, I want you guys to know that as well. But again, I remind you that you remain under order of the court not to discuss the case with anyone and not to read or listen to any reports about the case. No one is allowed to contact you concerning this case. At this time, I thank you very much. I'm very happy that the 12 have been able to remain here the past week and a half. And you're technically still a member of the jury and still under direction of the courts. Your notes have been collected. We're going to keep them because if you need them later on, we're going to obviously give them back to you. So I officially thank you. I have your numbers. And as soon as we know something, I'll certainly give you guys a heads up and notify you as well as to what the next step is. So talk to you guys soon. Okay, so to the 12 of you, you guys will now be taken back to the jury room here in a moment. The clerk will collect all the evidence and the jury instructions and the verdict forms and bring them to you. Mr. Gray will collect your devices that we talked about. And given the instructions I mentioned earlier, we'll wait to hear from you. You can officially bring your notes with you. Oh, I'm sorry. One thing, I failed to mention this. So we have a firearm and we have ammunition. I can't give them both to you at the same time. I'll give you the firearm. If you wish to switch, let the bailiffs know.
Come on, jury. We depend on y'all. Think about the citizens. That baby gone, man. Child is gone.
Jury's outside our presence. You guys may have a seat. I still have counsel for the state defense and Mr. Quiles present. Any exception or objection to the jury instructions as read to the jury, first from the state defense? There were a couple typos I want to fix on the jury instructions. Nothing major. I read it correctly to the jury. I just want the paperwork to reflect what I read. There was a couple, yes. Yes. So I'm going to fix that before we go back.
He liked that camera on him. The judge did good. Judge Anthony Salem, you did a good job. Judge R. Anthony Salem, you did a good job. You really did. You conducted your courtroom with dignity. No disrespect at all. Michelle did her as a defense attorney. She did an awesome job for her defense. And the state did I can go up higher. They did a tremendous job with Iyana Sawyers. And what did he say? And I want to tell the mods and the people
who
a
clean copy
participated in it. Chat, y'all awesome, man. I don't know where y'all come from. Y'all some awesome people.
Defense.
I want to thank those who watch. We got other trials we got to handle
and the evidence, and just
fix.
We'll wait to hear from them. They've been clear instructions about how we're going to proceed tonight. So the ball's in their court. So we're in recess.
So, let's see what they doing over here. Y'all did an awesome job. If it wasn't for you all, I wouldn't even be awake. How can I did it? Ooh, wait. Oh, this has been so tough. Hold on, y'all. Let me move this out of the way. Yeah. It's been it's been a tough roller coaster for me, a roller coaster ride, trying to stay awake and going to work. And I depended on y'all. Y'all did. I mean, it's something about this group right here. Y'all kind of very special. I mean, something good. I don't have to be there. I can upload a video and y'all there. I mean, y'all handle y'all business like grown people. I like that. Can't ask God for nothing no better than that. But what I do need to do is get my I would like for my mods to email me. My email is inside. Go to my channel. Go to let me see, can I show you? Go to let me look. I need for my mods to email me. Immediately. Let me see. Go to let me see. Hold on. Let me see. So my mods, make sure you I appreciate y'all this guy who lived across the street. See, y'all, let me ask y'all something. That boy who took the stand, that had to been the young man who stayed across the street. And I wonder, was that him? You know, cause they say he had moved. I like him. He defended, he really offended, defended Iyana. Yeah, he did an awesome job. The young boy who told Michelle she attacked him. I don't know if Michelle knows she's doing that. I wonder, do she know she's doing that? Because sometimes in cases it's like you have to I don't know if she meaning to do that. I really don't. I don't know if she means to do that. If that's part of her complex when it come down to being a attorney, you know. Cause like me, I don't coach boys and girls track, so I can come off. I'm working on it. I can come off as to some of y'all as not arrogant, but it's more like, I don't know, but it's something you'll say. It's something about my. It's just I'm used to discipline, so I'm used to discipline, and I'm coming out of. I'm working. I got a long way to go with that, so I do apologize a lot. But yeah, I coach, and so my demeanor is different. It's totally different. But I'm working on it, y'all. I'm working on it. But think about if you was coaching 16, 17 years, that's a long time. And dealing with discipline, y'all go to y'all cheerleading football games, y'all go to y'all kids' track meets, y'all go to y'all kids' baseball game, and the coaches, they discipline, and I discipline mentally, physically. But I don't touch them or nothing like that, and socially. And then I have to go to their classes, sit in their class. So it's a lot that I have to do. So I'm thinking about Michelle. I said, I think that Michelle, as an attorney, he spoke to her. She stepped out of it. It's just like me. I couldn't bring my coaching home to my kids. Sometimes I caught myself with that discipline here when they didn't do nothing, and I was like, oh my God. I said, I don't need to do that. So, you know, there's a lot of things people have to work on, but it's not going to be easy. It's not easy, but time, you know, give people time. They can't change, you know. But y'all did a real good job. So y'all, what we doing while we waiting on the verdict? It's something I want to see. I saw at the beginning when I came back that I missed.
Verified that.
Not that.
They went off of that and they left.
Here. I saw something I want to pull up. Oh yeah, I like this boy right here.
How many times had you and IS slept together?
Once.
That's him. That's him.
Have you ever?
That's him. Somebody asked me. That's the boy that what's the name was jealous of. What the name? I know he wanted to eat that boy up in the courtroom. That boy the same round the same way she is. But Jonathan don't like him. Jonathan don't like him. Yeah, he did an awesome job. I like him. He came in there and he spoke the truth. He said what he said. And he said, yeah, I lied to you. He reminded me of DL. DL did not like Henry Dinkins' defense lawyer. Like he didn't like the defense lawyer. But he liked the prosecutor. When the prosecutor talked, he was happy. This guy right here was. That's how DL was on the stand. He was happy to get a prosecutor his information. I thought that was cute. I picked up what he did. What she said. What she said, I need Bible study. Let me pull something else up. Okay, let me see. Let me see. I thought something else I wanted to bring up. I like that him. He did his role. Let me see who else. Chumsy did not like that man right there. Let me see. Shoot that girl. Put that girl over there in that dumpster, y'all. Shot that girl, strangle her, and then put her on the couch. Put that girl. Strangle that girl. He was gone for his lunch break for the longest. Strangle that girl. Picked her up, strangled her because she wouldn't die when he was choking on her. God wasn't ready for her to go. So he take his weapon and he shoots her. And he did it on his job. Then he threw her beautiful, the young girl body over in that dumpster. Like she wasn't nothing. Jeez. Because you know, when he planned this, y'all, premeditation. I mean, look at him. What is in his brain? And then, too, I'm going to be honest with y'all. It's still something going on with that family. There's something going on with that family because when they spoke on, what her name? Hold on for 1 second, y'all. Woo. Yeah. I know what I want to share with y'all. The auntie. Now, Auntie did some things that I don't know. It's what happened. Let me turn it down for a minute. Everything is allegedly. Everything I say is allegedly. Okay, because I don't know them. Well, I got an opinion. I can speak my opinion. The auntie, something. I wonder have this ever happened with them growing up, coming up, or anything like that. The reason why I say that because she let this dude right here contact them girls on Snapchat. That part I don't understand. My girls, ain't nobody gonna be connecting to them, period. She knew that they was communicating on Snapchat. What? A grown man contacting them girls? And all of this stuff going on. That part, I don't understand, and she knew it. No, don't nobody husband got no business with their niece's Snapchat and Instagram page. They don't supposed to have that. That ain't cool. But I can't tell nobody else what to do in their house. You know what I mean? But I that's one thing that kind of like disturbed me. And then when she said that the family got into it, the family separated when Iyana got pregnant. And when Iyana said her baby was by hold on, y'all. Let me keep it right here so we won't miss nothing. When Iyana said she was told the family she was pregnant, when she told the family she was pregnant, and they got into it, she said it was by a Spanish name. I don't know why that didn't ring no bell. Grandmother even said she saw some things that he used to hug on Iyana, like it's a different kind of hug. He even told yeah, that's what I want to show y'all. Hold on for a minute. It's put, let me see, it came on, let me see, it's right here. Let me find it now. Right here. Yeah, let me see. Hold on. Oh yeah, I want y'all to see this. Okay, on anonymous. Okay, this is what I wanted to go over, this part right here. It said this is what everyone have to do anonymously. Did the crime occur? Hold on, y'all. I ain't mean it. I meant to stop it. This is the closing argument for hold on. Let's see. Yeah, this. This what the prosecutor was telling them. what does everyone have to do anonymously? Did the crime occur? Did the defendant committed the crime? Each of you will use the following evidence presented during the trial. The law that is instructed by the judge, common sense. And it's this here. And then they went on to say, this what I want y'all to check out. Oh, and let me make sure I got my phone on the case. Hold on, y'all. This is very important too. Hold on, y'all. Okay, this is something for if you find Jonathan Quiles committed manslaughter, you also find beyond a reasonable doubt that during the commission of the crime, Jonathan Quiles carried, displayed, used, threatened to use, or attempt to use deadly weapon. That's going to be very some good findings that they're gonna have to look for. How long, y'all? Let me see. And this, did the witness have some interest in how the case should be decided? Does the witness testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? This is weighing the evidence. Well, hello, how are you? And moving on. Then they said overview of the witness and officers. Okay, Albert, Detective Albert. These are the witnesses that the state provided in their case and more. The defense witnesses, these are the was Kamar Humphrey. S contact case was gone on December the 19th and 12/20 specifically. Carol Klimpton saw individual for five. So that's the white older lady who came in the courtroom, and Eustace Dixon 5-time CF known these several years, 16 pending charges. These are the defense witnesses. At 11 to 11:39, 12:19, state 35. See, he was binging and he didn't even know it. And these were some of the things that they found that belongs to the young lady. Now they kept on saying these here was size larger. Maybe she had to go a size larger. She might had to. She probably gained weight, didn't even know she was gaining weight. The Snapchat, the message is the state. I'm too jealous with you. I couldn't even sleep last night. Huh? See, this Snapchat gonna tear him up. That's why. Wait, hold on. Yes, and thank you. This information right here with the Snapchat, but the auntie know that they communicate like this, y'all. That's what I don't understand. it's a lot of women kind of careless about letting their daughters do stuff like this or their nieces. But this gonna be very important. I know they're in there talking about their Snapchat. This right here. I'm not going to see how they wrote that twice. Have you stay the night anymore? Anyway. So whatever you really did this time, you aunt and I was getting a divorce, and you and I, once you hit 18, was going to break out. What? Are you serious? Oh, Lord, have mercy, Jesus. This dude right here, they got to get him off the streets, y'all. He been waiting to divorce her to go marry her daughter, her niece. And then right here, the wire, we was talking about the wire, and you pour some water where the blood was. Yeah, no, it's just it's dirt. You just scoop it up, effing move it, scoop it. Y'all fixing to run away, yeah. You faking it, yeah, boy. You slime, boy, and if your wife, sister kid, yeah, she was my little baby. What? Y'all been effing how long? Probably maybe a year. Probably less than that. This is sickness. Man, I'm telling you. Woo-wee. You right there, boy. I tell you. Woo-wee. Sure was. I can't put that word up there, so I can't. I got to move that. So I got to move that word. They don't want that up there. But yeah. I mean, listen to it. He was gonna take that girl, snitched on himself. And he supposed to had a broke leg or something. That's why they was coming over there. But they said he was inviting Iyana over there when Iyana yeah, it's okay. They was inviting Iyana. Oh, Iyana was coming over there when the auntie went there. What? These days, you got to keep all eyes open. What you believe, check into it. Examine it. That baby gone. She was in the 10th grade. 10th grade. And y'all, and know what? You all was so right. We kept talking about the sister. Remember, we kept on saying he had, if he did the sister, if he did Iyana, he had been on being with that sister. We kept saying that. And true enough, it came up even with the sister first. God, but I'm thinking now, what about her daughter? You know what I mean? It's kind of scammy now. What, a person like that don't care. Now I'm thinking about the daughter. The baby, the little bitty baby girl. Have that ever happened to her? She don't know no better. She ain't but 2. I mean, he left work. Yeah, and the other family member in the auntie gonna say, "Oh no, I don't know about her." The other cousin. It ain't time to be talking sexy. It just. And we knew what her name SS. We knew she was hiding something. We kept on saying it, y'all. We were right the whole time. Everything we thought was put it on the table and for some analysis and analyze it ourselves. It was right. All of us put this case together. Yeah, we put this together. I like crumble because we got yeah, poor little babies, man. This don't make no sense. I'm thinking about the little girl now. And then I felt so sorry for his brother. The brother had to tell him. The brother had to tell him. Yeah. I tell too if it's for another family to get justice. And then he said he put dirt on the BLOOD. And I'm like, now he used dirt and Henry Dinkins used Clorox to put on top of the BLOOD. Yeah. And what about her brothers? Yeah, you right. And the brother too. But they got a little brother too. You know, I did for a moment because I was like, where would he burn her body? He went well, whatever he did on his lunch break, he came back like did nothing happen. And I believe they scared of Henry, not Henry Law, him Munson. I believe they're afraid of Jonathan on that job. They don't mess with Jonathan. Oh, and then and another thing too, y'all. He lied about being a police officer. I knew we already knew he was. We knew that. See, I'm gonna tell you something. Jonathan did something that Henry Dinkins did. See, Henry put all of it on the L. He made the L be his spokesperson. Now Jonathan ended up being his own spokesperson. He took us through what he did to her. And he don't even know it. He's sick. He's sick. That's right. And I wish, people like that get help, that's them. But it just he used his wife, he used the girls, he used the boy next door. Soon the police came over there when we watched that footage, that camera footage when the police came over the house. The only name he kept saying was the boy next door, that little boy who took the stand. He didn't want nobody around Iyana. Oh my God. See, he been playing this. He was talking about they were gonna get a divorce and then he was gonna marry her. And Iyana said she was gonna run away if he wanted her to get rid of her baby. She was talking about running away. They supposed to be running off, y'all. That's why the grandmama said she was gonna graduate early. See, she about to be grown. That's sad. That's it. And when you can't protect a kid, yeah, then laugh about it, sure did. Girl. See, and then that inmate, the guy had the green on, he told the truth. And Pimp Daddy, who came in there, he preaching. The pimps always preaching. They always preaching. He in there. Ooh-wee. The pimp in there preaching, and I guess they have to get him what you call it for the pay canteen, get him some of his food give me some kind of donation, some potato chips and all that kind of deodorant. You know, that's why Henry he, he was the same type. That's why Henry got out of it, y'all. Henry see the devil ain't gonna and both of them can't battle each other. They can't battle they couldn't battle now. See, one thing I see that them two have in common, they love their hair. The hair is what catch the girls. Their hair, that pointed tail. Both of them got their hair. See, Henry hair start getting old. His hair start getting old. Listen to me, his hair didn't get old. So did. They both had hair on the head. You know these young girls like that. Yeah, it's a. This was a good case, y'all. But it sure wore me out. But I appreciate y'all because we went from one case to another case, and y'all, we got to find out what happened to that girl. Uh, what her name? Tamil Taylor. Tamil Taylor. One, but 21. She ain't disappear off this earth like that. It's sad, boy, how people they doing. How these young folk doing each other. How she gonna just put her phone down? She puts her phone down. Tamil Taylor put her phone down. And on the way she'll put her phone down, she didn't want the phone to be. What's up with these phones? They don't find out that the phone be being wherever they go. Everybody had a phone. Everything worked around the phone. Jonathan was sitting in between them girls' legs. Yeah. And had them messing with their hair. Brushing it. Looking like, let me show you a picture of him. Looking like Wolfman Jack right here. I don't want to talk to me, but I like his brother though. There you go, right here. Oops, honey, I don't want y'all to see me laying down with my head wrapped up. Hold on, Henry. Not Henry, but there you go. Mm-mm-mm. A nice man like that, a handsome young man like that. Something happened to him. And his brother, I appreciate him. His brother, I really appreciate him. I appreciate him. Yeah. And then he said people in jail don't got something against him. People in jail don't like people on earth don't like nobody like that. Yeah. Yeah, make you wonder what happened to him. Yeah, something. And them sisters too. Them 5 sisters. Something happened right there. Something happened right there. I don't want to say too much about stuff like that because they don't be want you to talk about it. But I think they did a good job. I think the judge did a good job. I was just more sleepy and tired. But the judge did a good job. The lawyer, the attorneys did a good job. I think everybody played their role in this real good. I think everybody did, and y'all did an awesome job. But oh my God, it seemed like y'all played tag team. Wow. Mm. But I'm gonna tell y'all, if they go in that room, that judge and that prosecutor, that judge and the last prosecutor were on it. To my in this case right here, to my Miss Cunningham, the lady in this one. Let me see what the lady. I don't know her name. This one right here, I don't know her name. Let me see, can I find it? Let me get her name. Because I like Miss Cunningham, the one Henry Dinkins said. I like Miss Cunningham be chopping you up, boy, real sweet. Mm-hmm. She said, mm-hmm. But prosecutor for Jonathan Quiles. Prosecutor name, let me see. Honey, I like Miss Cunningham. I wouldn't mind. I like me, Miss Cunningham, boy. Ooh, I love her, honey. I ready for her to represent me for anything. Goodness, turning name. Wait a minute. That lady right there, she said, mm-hmm. Even if they wrong, she said, mm-hmm. But hello, precious. She said, mm-hmm. Okay, the prosecutor name, the man name is Daniel Skinner, y'all. And French would have to prove that Quiles is guilty. Okay. And guilty through witness testimony and evidence and legal team of Bob. Okay, legal team of Bob Davis and Christine Rachel tested with defendant Quiles. But I don't know who's worse, him or Henry Dinkins. I'm gonna tonight I'm gonna y'all notice I ain't did no upload because I was tired. I can't wear myself out like that. I won't want to wear myself out like that no more. I ain't even know I snore, y'all. I didn't even know I be snoring. I used to just wanna why my dog be jumping all up on me. And then when one of my children told me that I snore, I said, me? I ain't know I be making that much noise. Hello to you, Linda. That male prosecutor ended that big girl. Ooh, that Republican boy. I like him. I ain't even know he had that in him. And to be honest with you, Linda, I didn't even know he was talking. Yeah, I'm gonna drop the link in case somebody want to come up here. I didn't even know that man was talking, y'all, in the courtroom. I thought that lady was talking. I like they tag team. I like how they run their bid. Prosecutor did a good job. Prosecutor did an awesome job. And Linda did a good job for what she I know she had to be a defense attorney, but she did an awesome job too. Michelle. Because she did what she's supposed to do. We wasn't supposed to like Michelle. Y'all wasn't supposed to like us. But we don't have two good cases, two prosecutors who support now. I'm gonna tell you something. I'm gonna tell you another prosecutor. She act more like Michelle, but she need to act like she need to be strong like this prosecutor right here in Miss Cunningham in YNW Mellon case. that attorney that's who represented state, she another one. Yeah. See, when his brother, see what, okay, this is what his name? Jonathan. Say I still don't like me. Why you don't like Michelle? Michelle just don't feed into that. Michelle just but see, Jonathan didn't think that his brother was gonna come up there and testify against him. See, Jonathan and that young man who was locked up, who went to church with him, Bible study with him, who was his roommate, they had the same story about him. Yeah, she tried Naomi. Naomi hung on her real good. Naomi took her down good. And I'm gonna tell you too, that boy right here, this little boy right here tore her up, boy. He said, "Yeah, I lied because you was attacking me." He sound like DL. He sound like DL. He said, "Yeah, I lied to you. Yeah, I lied to you because you got him. I like him, and you know what I like about him. You know what I like about this boy right here. He said he was the neighborhood. Yeah, what I like about him. He said, now what you say? Repeat that, because attorney they'll talk so fast until you don't know what they talking about. She tried him, but he kept his proposal. She was trying to throw that come out under the bus. He put her. Sure did. Shoot, he said you was attacking me. Yeah, that's why I lied. Boy, this case was good. Golly. In both of them cases, a girl got shot. They didn't have to do that to them. Why didn't just leave them alone? Go on by your business. See, Henry thought he got away with his stuff just like I hope that the judge, not the judge, but the jury, if it's taking them this long, yeah, they were girls. They were females. Female. I hope the jury don't take, look, right now it's 5:42. They should be coming out of there. Unless somebody they need to think about that girl and that boy, his brother testimony. Man, this here, both of them cases had females, 2 young females. Man, yeah, I thought they was gonna link him to IS because of her plane ticket and him telling Michelle he took a plane to Big A. But you know what? Iyana messed his plan up because he thought Iyana must have lost interest in him. And then when he found out you were pregnant, it changed things. Yeah. That's why he got out of that little church in there, because he that's his job, the pimp. And the preacher was the pimp. He got out of Bible study, y'all. He got out of Bible study, and tell lies. He a liar. The brother said he ain't never been no police officer. He ain't never, everything he was telling, like, yeah, PIMP. That's what that little preacher said he was. And the little preacher, I thought he was gonna jump up off that table and on the prosecutor or somebody was asking him a question, and he was like, yes, yes. Like, and what? Yes. I was over here cutting up. Uncle Creepy. We don't get everybody name. We don't have a Henry Dickens 4SL, and we got Uncle Jonathan Quiles. Ooh, next. Oh Lord, help me, Jesus, help me, honey. Oh Lord. Mm-mm. That Jonathan think he done got away. And y'all know, y'all, we got to tell. We got to tell. I'm waiting on who is that? YNW Melly. I've been with their case. I've been with their case. Now that case right there, ooh wee, that thing about to be off the chain. So we got that one already. But we got to get another one good. This one right here told me up. This one right here made me so darn tired. This case right here wore me out. Jonathan got me worse than Henry, because I don't think I went to sleep on Henry Dinkins. I didn't go to sleep on Henry. But Jonathan messed my mind up. Jonathan messed my mind up. Because I can't believe he got rid of that. For real, chill. Shoot, he made me tired. I ain't never snore like that. I ain't never fall asleep like that. And then only reason why I stayed up this time because they took a lunch break. They took a early lunch break. Other than that, baby, I shut my eye when I got off in with y'all and took me a cat nap. They worked me. Shoot, this case right here, Jonathan throwing people all in the garbage and whoo, Jesus. He got me. Henry didn't get me this bad. We already knew what Henry did. But Jonathan being jealous and oh my gosh. If it wasn't for y'all, I would have just did me an upload and went on by my business. It was those girl, we said that. Girl, the Snapchat. And the auntie know they Snapchat. That's what tripped me out. It gone too deep, and the auntie let him do it. The auntie let him do it. She said they got to contact each other some kind of way. Them girls ain't got no business contacting that man. That ain't right. Ain't no but that ain't that ain't. And then she said he delete the mess. It deleted on Snapchat, but then it came back. I wish prosecution could have convinced Jonathan ex-wife in New York, the young relative ESA, to testify. I wish he could. Them Snapchats let everyone know exactly what they was doing. Sure did. And the mama, if it weren't for Iyana mom getting into her love notes, them love letters in her the love notes inside her. That's where they got them from, y'all. Out of her laptop. They went in that laptop and got that. That was evidence, baby. Jonathan got away. He thought he got away. You ain't got to have no DNA these days. You ain't got to have no DNA. Threw that girl over there in that dumpster. Jesus Christ. She could have still been living. We don't know. He don't. That was two people that took Iyana baby and Iyana. So you got a 5-month-old baby, like he took, and Iyana's. And he said, "No, I ain't taking no stand. I ain't taking no stand." Yeah. He said the same thing Henry said. He said, "I ain't taking no stand. I ain't taking no stand." I don't know how Naomi let that go under her nose. She saw it. She saw it. That's see, Jonathan was trying to tell on her. And Jonathan was trying to tell on her. Jonathan said she knew about this. I just know she wanted to sleep with that. She knew, but see, a lot of things that she did that you don't let young girls do. A lot of things you don't a lot of things you don't let them do. That's not their daddy. That man young. It's not their daddy. Don't trust no young man around your daughter. And he was trying to tell on her. He said she knew about them Snapchat. How that man ain't got no being contacting them kids on Snapchat. And I'm thinking about her little girl. Now she got a baby. 2 babies by him. Whew, Jesus. Now they should be done. They ain't came back yet. Late. He and us probably still trying to buy them pizza. Yeah, like he didn't want to go home. They ain't even came back. I know that little baby saw something too. That baby. Shoot, that 2-year-old girl probably trying to tell mama something she didn't know what she was saying. She working. I believe she older than Henry too. It's nothing wrong with young. I like him young too, but I believe she old, not older than Henry, older than Jonathan. It seems like she older than Jonathan. She tell Jonathan what to do. And Jonathan fell in love. Oh, golly. Jeez. This is a good case. Good case. Now I'm waiting on this jury, man. Please don't y'all take us through what y'all took us through with YNW Melly. Good. Jeez. I really want to know where Tamia Taylor. Tamia. I want to know where she is because she a young girl too. Y'all hang around older men. But see, she old enough to do that. She 21. She got it. Didn't nobody know that. The police didn't know that she had got into an altercation with somebody before she went on the trip to the ferries. Not the ferry, but the riverboat. Y'all like they on the riverboat making the food. Woo-wee. But whoa, they got me nervous, honey. Mm-mm. He probably went and bought them some pizza. Y'all did good though. We hooked that up. We put this thing together. like doing cases because I like collaborating with people like y'all, where we didn't say this person was wrong, this person was right. We took the information and then we try to adjust the information into it, and then when it didn't fit in there, we kind of like put it to the side. I like how we collaborated together on this case. It's like what we just did then. Then nobody said, "No, that ain't right." It's this. No, we ain't do that. You take all the stuff that people say and you put it together. Then it don't work like that. Take it out. It was good. I like doing cases like this. And I knew, uh, that SS he did something to SS. I pray a miracle happen and her remains show up. You know what? I do too. That baby deserves a proper burial. Yeah. I wish they can find the car. Who was? Jonathan? Oh, we had jury. I was saying, honey, we had girl. We worked this thing. Oh, who we had the judge. Everything we did this. Everything we said came out on the table, just like it did with Henry. We didn't let see if you let your feet off these crooks. I ain't let my feet out now. Not when it come down to no kid. Now the only reason why with cement, yeah, snap. Now see, what is that, y'all? Everybody be asking me, do I have would I be on social media? They want WhatsApp. What is it? WhatsApp. And then I said, what's a WhatsApp is? They said, go download WhatsApp and talk to me. I said, I don't need no WhatsApp because I don't even know what a WhatsApp is. Yeah, this man told me to download WhatsApp. If I'm saying it right, y'all, WhatsApp or what's up? I don't need that stuff. Why it ain't? Show you. Why it ain't popping up on mine? Oh, cause I ain't got it at the end. Why it ain't popping up? Thank you, baby. Very. Thank you, Ernestine. I got to put Ernestine thing, but I'm nervous.
Your Honor, the jury returns to the court.
All right, the verdicts are legally sufficient. I'm going to give it to the clerk for publication. Mr. Quiles, please rise with your counsel.
The Circuit Court of the 4th Judicial Circuit in Court, Duval County, Florida, case number 16 in 2019, CF 7518AXXXMA, Division CRI, State of Florida versus Jonathan Jacob Quiles, verdict count 1. Leave the jury found the defendant guilty of first-degree murder as charged in the indictment.
We find the defendant did actually possess and discharge a firearm during the commission of the offense. Verdict count 2. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. We find the defendant actually possessed and discharged a firearm during the commission of the offense. Verdict count 3. We, the jury, find the defendant guilty of engaging in an act that constitutes sexual battery upon or with a child 12 years of age or older, but younger than 18 years of age, by a person in a familial or custodial authority, as charged in the indictment. So say we all that in Jacksonville, Duval County, Florida, signed by the fourth person, dated September 21st, 2023.
All right, Councilman Sawyers, you may have a seat. Either side want the jury polled. Yes, Your Honor. Members of the jury, the clerk is simply going to ask individually a question whether this was indeed your verdict. I want you to disregard your jury numbers from last week. We're going to start from my far right first row, juror number 1, work our way down, and then commence back on the top row. So 1, 2, 3, etc. And we'll finish up with juror number 12 on my far left. So she's going to ask you a question, and you just respond with your answer.
Juror number 1, were these your true and correct verdicts? Juror number 2, were these your true and correct verdicts?
Yes.
Juror number 3, were these your true and correct verdicts?
Yes.
Juror number 4, were these your true and correct verdicts? Juror number 5, were these your true and correct verdicts? Juror number 6, were these your true and correct verdicts?
Yes.
Juror number 7, were these your true and correct verdicts?
Yes.
Juror number 8, were these your true and correct verdicts?
Yes.
Juror number 9, were these your true and correct verdicts?
Yes.
Juror number 10, were these your true and correct verdicts?
Yes.
Juror number 11, were these your true and correct verdicts?
Yes.
And juror number 12, were these your true and correct verdicts?
Yes.
Members of the jury, this is typically when in the process I dismiss you from your service. However, we need to move forward with phase 2 of the proceeding. That will not occur tonight. It will not occur tomorrow. I'm going to give it a day off tomorrow. We're going to start back up on Monday for that process. That's what I told counsel as we were planning this out, and I want to abide by that. That phase, and the attorneys agree, is not nearly as lengthy as what this process is. A couple of days is what they anticipate. We may
They
be able
did
to do
good.
on Monday. It depends how things shake out. Therefore, you're still under the order of the court to not discuss this case among yourselves.
Oh yeah, my heart just beating.
Well, you discussed the case. You can't discuss it again moving forward. Please disregard the media. Please don't watch the news or the newspapers. I know it's a 3-day weekend.
Put it on Jonathan.
Please
Put it on
It's
Jonathan.
very important you do so. I'll have your 4 other friends come join you back on Monday, and we'll reconvene at that point. I haven't talked to the attorneys about this, but I'm tempted to begin later on Monday. Monday traffic's a bit more chaotic than the rest of the week. Why don't we start at 10 o'clock on Monday? Give you guys a late start. You guys can have a cup of coffee on me. Just tell them that.
Man, come on, put it on Jonathan.
We'll start at 10 o'clock on Monday. We'll have a full day again. We'll go from there. I'm going to talk to the attorneys today and probably tomorrow and get an idea of what next week looks out for us. At this point, I'm going to dismiss you guys for the day. You can get your belongings and just meet. I trust you guys to get here on time Monday. Get here before 10 o'clock, same place as you have the past couple weeks. Just remember, do not discuss this case with family or friends. Please stay away from the media and newspapers. If you see it, mute it, walk out of the other room. The same thing you guys have been doing the past 2 weeks. You guys have been wonderful. I commend you guys. It's a solemn responsibility, and I
Put it on Jonathan. I want to see Jonathan.
And, with that said, I'll see you guys Monday morning at 10 o'clock.
There you go. You ain't smiling now. You gone, boy. They waiting on you, sweet tooth. We don't got 2 justice, y'all. And he ain't even crying. Look. Bye.
Outside our presence, you guys may have a seat. Anything we need to handle? Hey.
Your Honor,
Yeah, it's
Monday.
over with.
Yeah, I told you guys that earlier in the weekend. I want
Bye,
to that so you
Jonathan.
guys have time to prepare over the week, over the 3 days.
Bye. Go on back there and put on your green
Give the best
uniform.
perspective. I do want to have a short status conference tomorrow to talk about the penalty phase, scheduling wise, instructions. The aggravators listed by the state, the mitigators listed by the defense. I want to get a clear idea as to the mitigators, statutory and non-statutory, listed by the defense and pleadings, and have that box.
Yes, girl.
Because they need to be listed in the instructions for the jury.
We did
I have a
that.
good idea of that. I know the defense has filed a couple pleadings with statutory and non-statutory ones.
We did
some
that,
of the
lady.
non-statutory ones you listed seem to be listing aggravators, but like in the inverse, how that aggravator is not met, which that may be what you're arguing as a non-statutory, but I just want to get a good idea of what we're
Bye,
talking about.
Jonathan. I don't want to hear all that. Bye, Jonathan. They gonna get
I want
Jonathan,
that to be
y'all.
specifically delineated in a pleading. That's what I'm gonna talk tomorrow about. About getting
You
that
know, when
one
they told that man that that boy was
So it
doing
lists out
drugs
everything.
in
If
jail,
that's a combination
boy.
of what you already filed into one pleading, that's fine. I think it's important to have that one pleading done so we can handle that.
You want it before we come to court tomorrow?
Or you can have a draft done and we can talk about it tomorrow if you would like.
Ooh, sure was.
I know you have Dr. Rohr, correct?
Ooh.
Dr. Rohr?
Yes.
Okay.
Stop,
And I
Campbell.
can tell you that it's going to be very short. The state and I, we're meeting with Dr. Rohr here at noon so that Mr. Skinner can go over whatever needs to be done. And we'll have
Girl.
an opportunity to be able to speak to her tomorrow at noon.
Did she do the IQ test you mentioned in the pleading? Okay. What time do you guys want to have a status tomorrow? I can't imagine it'd be lengthy, but if you have that noon meeting, what do you want? 11's fine with me.
11 o'clock, great.
And we'll have it in this courtroom as well, since that's why we're here. Certainly appreciate you guys. I know it's been a long couple weeks. Appreciate both counsel and both
Sure
sides.
have
for your
been a long
professionalism
week.
and how you guys conducted the trial. It's not
Ooh,
easy. I
have we
recognize
over
that fact as well. So appreciate you guys. And I'll see you guys back at 11 o'clock tomorrow.
We did it, ladies and gents. We did it. We did it. We did it. Hey, we took that one down. Hush, Campbell. We took that one down, y'all. We did that, ladies. It's 2. We got 100 more to go. Wow, this was good. Oh, wow, y'all. I appreciate y'all. This thing is so but the uncles too show do the uncle, the aunties, the cousins. Girl. Oh, and then you know what? And Jonathan told on that guy who was selling drugs in jail too. Oh. You remember them guys did that was wiring on him? Oh. But ladies, I appreciate y'all being here. Lanita got to go upload some videos for y'all, and we got other cases. We got to go to these sentences. Sentencing, Henry sentencing. We got to come back, Hush Camper. We got to come back to here. We got to come back here and finish him out and make sure we got his paperwork done. But y'all did an awesome job. Y'all did it. We got some more cases. We got to go at them. But y'all, I appreciate y'all. I'm about to put some uploads and some updates. I appreciate y'all. Ooh, Chad. I'll see y'all later, okay? Thank you so much. And those who watching, thank y'all too.